Hello everyone, so welcome back to the English Law channel and continue the criminal law, talking about recklessness now. So there's this mental element of some crimes called recklessness. So that is doing something when you know that harm can result. You don't wish harm to result, but you're not trying to avoid harm resulting. You're going ahead doing this dangerous thing anyway, even though you know it could hurt someone. So the trouble is that recklessness has sometimes been interchanged with negligence or gross negligence, particularly in relation to manslaughter. So in principle, these two or fault elements are different. Recklessness is a subjective fault element, and you need proof that someone was aware of the danger or they thought about the danger. But negligence is an objective fault element, and in recklessness, negligence, you do not need any awareness of the danger. You do not need to be thinking about the danger to be guilty of it. So the usual meaning of recklessness is purposefully taking an unjustified risk, and the defendant knows that he's running a risk. So so the defendant needs to realise there's a risk, and that, as per Cunningham 1957. In that case, the defendant, he tore a gas meter out of the wall of a house because he was going to steal it. Gas escaped from the pipes, therefore it got into the neighbour's house and it injured the neighbours. So the defendant was charged with unlawfully and maliciously administering a noxious thing so as to endanger life. And he was found guilty under Section 23 of the Offences Against the Persons Act, against the Person Act. So his conviction was then overturned on appeal because the judge had misdirected the jury when he talked about malicious, because remember, he had to have maliciously done it. The judge said malicious, well, that's wicked. The Court of Appeal said the real meaning was laid out by Professor Kenny in his Outlines of Criminal Law. This is what Professor Kenny said. In any statutory definition of a crime, malice must be taken not in the old vague sense of wickedness in general, but as requiring either one, an actual intention to do a particular kind of harm that in fact was done, or two, recklessness as to whether the harm should occur or not, i.e. the accused has foreseen a particular kind of harm might be done and yet has gone ahead and taken the risk of it. It is neither limited to, nor does it indeed require any ill will towards the person injured. End of the quotation. So that definition was followed in Briggs' Note 1977. This was about somebody pulling on a door overzealously and then damaging the door. So if you're aware of the risk, that doesn't mean that that you necessarily had some clear thought about it. So this is about crimes of malice. So malicious wounding is one of the key ones here. That's enough for the moment.